Counsel, I'd like you to the chief makes it an either or. Most of the Court of Appeals who have sided more with you than with amici recognize that the savings clause cannot be invoked every time a 2255H applies without blowing it up. So you have to have some limiting principle. And the limiting principle that most of the Court of Appeals have found is the one proposed by the government, which is that they thread the needle by saying that innocence claims should be one of the rare cases where the savings clause is triggered, because otherwise there would be a fundamental miscarriage of justice. Now, your brief did not go as far as the government in saying that. Are you eschewing the government's position, or are you accepting it?
No, for purposes of this case, Your Honor, we accept the government's position. We believe that there's not much daylight between its position and ours on purely statutory claims. We not necessarily agree with it across the board. For example, their interpretation of when 2255H2, for example, does restrict traditional habeas relief for, say, constitutional claims. But in the universe of statutory claims, there's really not much daylight on the ground between their position and ours.